So welcome everyone to another webcast here at Berkeley Law. This is the Berkeley Center for Law and Technology's Expert Series webcast. And today I'm excited, and I know that those of you who have come to these programs say I'm always excited about it, but we just get expert after expert. But these two experts are probably among the top 2, 3, 4 in the field in the United States, and to have them together is a rare treat for anyone in the cybersecurity space. So I'm going to start with Jim Dempsey on the introduction. Those of you that know BCLT know Jim Dempsey. He ran BCLT for many years, and maybe in 5 or 6 more years, I can kind of reach the same level of achievement that he reached. So in addition to running BCLT, Jim is also an incredible scholar on all cybersecurity matters. He retired so he could focus not on Berkeley admin issues, but actually focus on the law. And what he's done since then has been fantastic. And then you couple him with one of the top practitioners in the nation. When you talk about cybersecurity practices, data privacy, Miriam Wugmeister comes up as the name over and over. So she is head of the group, Data Privacy Cybersecurity Group. I forget the exact name that Morrison Foerster uses, but I'm just going to make you in charge of everything data related at Morrison Foerster. And so when you look at client ratings, but you look at the type of work, Miriam has just an incredible breadth and background. So when you combine these two together, this will be quite a presentation for anybody facing cybersecurity questions or issues. This is not something you can afford to miss. So with that, I'm going to turn it over to you and get out of the way. So thank you both for joining us.
Thanks so much, Wayne. Great to be here, and delighted to be at a BCLT event. You've taken the organization to new heights. One of the best decisions I made was recruiting you and getting you into the executive director position. And as you say, to do this with Miriam Wugmeister is just fantastic, since she is such a leader in the field. We're going to jump right in. We've got a lot to cover. A lot happened last year. And Miriam, you're going to kick it off by discussing this, to my mind, major new regulatory regime that was created at the end of the year regarding Americans' sensitive data and certain data regarding government officials. But tell us all about this DOJ rule.
Yeah, so it's the DOJ rule on bulk sensitive data, but it's really a security rule more than anything else. So it started with an executive order that President Biden signed in February 2024, and it's rooted in the International Emergency Economics Powers Act. And that's the authority under which Biden directed the Department of Justice to create and enforce this regulatory program. It's focused on access to sensitive data of US individuals, and it's limiting access to that data from China, Russia, Iran, North Korea, Cuba, and Venezuela. The real goal of the law is to limit what information is available in China so that the Chinese organizations can't get ahead on developing AI. That is really the goal. And when you look at the rules, it really is going to discourage anyone from sharing information, having affiliates, having vendors, having business partners in China who have access to any of the sensitive information. Like Jim said, there are limitations on sensitive personal information and also information on government data. So the sensitive data includes at a very high level. And for those of you who are interested, we're doing this super fast. There's another whole session being done as part of the series that's going to do a whole hour just on this topic. So for anybody who wants more, that's available. That's coming. But the sensitive data that is covered here is biometric data, personal health data, personal financial data, precise geolocation information, genomic and other omic data. It's not a typo when you see it. We all thought it was a typo when we saw it. And then also personal identifiers like IP addresses. So it's much, much broader than what you think of when you think as a privacy practitioner of what is considered sensitive information. there also are exemptions. And when you first read these exemptions, you're like, okay, this is pretty good. It's financial transactions, it's clinical trials, it's travel data, it's sharing with affiliates. But those exemptions are much narrower than they appear. You actually have to read the examples and the commentary because that makes evident that what they mean is that it's a financial transaction, but that has a connection to China. So the examples make clear that the exemptions are much, much narrower. One of the other things which I think people don't realize is that even if you don't have employees in China, if you have any third parties outside of the US with whom you share information or who you allow access to your information, you have to update your agreements with them. So if it's vendors, if it's business partners, if it's affiliates, you have to update your agreements. Oh, and you're supposed to do this by April 8th. This all goes into effect April 8th. The other thing just to say, and then Jim, love to hear if you have anything to add, is that the Department of Justice is the regulator. And this is not like, we don't normally think of the Department of Justice as a regulator. We think of them as an enforcer. But because this is the Department of Justice, it has civil penalties of up to, of twice the amount of the violating transaction, or about $350,000, and criminal penalties as well, of up to $1 million or imprisonment of up to 20 years. So the Department of Justice is kind of serious about this, the way it's being drafted. And like I said, I do think it's possible that the compliance date will get bumped out past April 8th by 60 days, but we don't think this is going away.
Well, Miriam, you hit on or hinted at what was going to be my question to you, which is, will the Trump DOJ enforce this, and will it be affected by the so-called regulatory pause, or at least the potential for regulatory pause that President Trump has directed agencies to take?
That's a great question. So this executive order was not on the list of executive orders that were repealed. It's on the list that says, you might consider extending the deadline by 60 days. So that's actually where we think it's going to go.
Yep.
But remember that the kind of limiting the access that China has to US persons' data for purposes of developing AI, that was started in the first Trump administration.
Exactly.
So this is something that is bipartisan. I mean,
Exactly.
right? Republicans and Democrats both are worried about competing with China, right? So we don't think this is going to go away.
Well, and you mentioned the Biden executive order that directed the DOJ to develop this rule. That Biden executive order was based on and invoked a Trump executive order, 13873, which launched us down this road.
Exactly. And the folks who are sort of in the interim positions within the DOJ they worked on this. Like, so this was very much, bipartisan development, these DOJ rules. And just to add, like, DOJ has added, I forgot, somebody told me it's like 40 people.
Wow. Interesting.
To get ready to launch and to enforce this. So there's a lot of momentum behind it.
Right. And so basically, you're going to have to go back to the starting point, look at all of your business relationships, all of your employment relationships, all of your investor relationships, and look at where might data be flowing to China or this handful of other designated countries.
Exactly.
So,
and
as you say,
can I just add one other thing? I think we're going to see like a battle of the forms, kind of like we did after GDPR put in that, everybody had to update their SCCs in like 30 seconds, right? Everybody's going to be sending these amendments to their agreements, to their vendors, to their business partners, to their affiliates. So there's going to be a lot of battle of the forms, kind of just like we had with the SCCs coming up in the next few months, I think.
Very interesting. Yeah. Well, as you said, there's going to be in this BCLT series, there's going to be a whole deep dive there, but we really couldn't let this one go unmentioned. At some level, it is a cybersecurity measure. We know the Chinese hacked into OPM and stole a lot of data. The Chinese did the Anthem Health hack. The Chinese, I think, did the Equifax hack. And basically, this is saying, well, sure, they can hack it, but what if they just buy it or get it through commercial relationships? We've got to close the front door.
That's right.
We're worried about them coming in the back door. This is an effort to limit them through
Yeah.
commercial
That's right. That's
relationships.
exactly right.
Well, let's turn to the Federal Trade Commission. Of course, everybody listening should know that the FTC, for more than a decade, has been the nation's de facto and default cybersecurity regulator, at least when it comes to the protection of personal data. And last year and into the first few weeks of January, we've seen a number of important enforcement actions by the FTC that suggest what to expect under the new commission leadership. Just a week ago, when we're recording this, January 15th, 2025, the FTC announced a proposed settlement with the web hosting company GoDaddy. The complaint against GoDaddy is similar to many that we have seen, alleging that the company failed to implement reasonable and appropriate security measures to protect and monitor its website hosting environment, and that it misled customers about the extent of its data security protections, failure to manage software updates, failure to inventory assets, failure to use multi-factor authentication, failure to log security events, etc. And the settlement, proposed settlement in the case, has this long list of security measures that, again, should be familiar to anybody from past FTC enforcement actions. To me, what's significant about the GoDaddy case is that the commission voted 5-0 to issue the administrative complaint to accept the proposed settlement, which means that the new chairman, this was before he became chairman, but Commissioner Andrew Ferguson, a week ago, a commissioner, today, the chairman, he voted for this. And so did the other Republican member of the commission, Melissa Holyoke, including not only the deception count that GoDaddy had made all these statements about how secure its system was, which the FTC alleged it wasn't secure and that the company hadn't done what it promised to do. So therefore, deception under Section 5. But also they joined, as they've joined in earlier cases, the count in the complaint that alleged that it was unfair of GoDaddy to collect personal information about individuals and not protect it with adequate security measures. So it looks like we are going to have, even when the Republicans gain control of the commission, Lena Khan, as of today, hasn't stepped down. She will step down completely soon. It'll be 2-2 for a while. Then ultimately the fifth member, another Republican, will be appointed. So it'll be 3-2 Republican Democrat. But still the majority clearly supports the exercise of the unfairness prong in data security cases. Another interesting recent enforcement action, September, the FTC and DOJ announced a $3 million penalty and a permanent injunction against a company called Verkada. Verkada offered cloud-based building security. They sold security cameras to over 12,000 businesses in a variety of sectors, including education, government, healthcare, hospitality. And again, the government alleged that the commission had failed. The government alleged that the company had failed in multiple ways to protect the data collected by these cameras. Now, two things are interesting about that case. One, not only did the FTC allege data security failures under both unfairness and deception, but it did what it does in all these cases. It looked holistically at the company's data practices and at its other practices. It found, for example, in the course of the investigation, that the company employees had been posting positive reviews of the company on a third-party site without disclosing that they were actually employees of the company. And this resulted in a separate deception claim apart from the security failings. Also, the FTC uncovered violations of the Can-Spam Act in terms of the company's commercial emails. And that resulted in a separate count or claim against Verkada. So this illustrates the point that once the FTC comes in, if it was a cybersecurity breach that triggered their inquiry, they will look at privacy, they will look at other aspects of the company's behavior that might fall afoul of either the Section 5 of the FTC Act or other laws enforced by the FTC. Or if it comes in on a privacy issue, it will look at cybersecurity. So be prepared when the FTC comes calling that whatever was their initial sort of trigger, they will go broad. Secondly, the case is very interesting in a way because Commissioner Holyoke, again, one of the Republicans who will remain on the commission, she filed a concurring opinion. The filing of the complaint and the stipulated order were 5-0 again. But Commissioner Holyoke said in a concurring statement that she was concerned with these prescriptive FTC data security orders. She said, all of these requirements, very granular, that we are imposing on settling respondents, they are too rigid. They're not risk-based, she argued. They're not flexible. And after all, these orders last for 20 years. So you're requiring people to do things for 20 years. It'll be very interesting to see if in coming cases she begins to push and maybe pushes her Republican colleagues to be less prescriptive in these orders. Miriam, thoughts on FTC? You've probably been in there representing companies. What's your thoughts on FTC enforcement?
So just a couple thoughts. So one is on the very last point you were making about the prescriptive requirements. What's funny is that when you talk to companies in other countries, they're so jealous that our regulators actually tell you what you're supposed to do. Because all these countries' laws have use reasonable organizational and technical measures to protect the data, right? And then the companies have absolutely no idea what's industry standard. And one of the things that's helpful about the FTC is they issue white papers. They have, and in their orders, they tell you, this is what we care about. So it actually gives a lot of certainty. So I totally appreciate the point about prescriptiveness, but actually for a lot of companies, like, okay, fine, you want me to have MFA, I'll have MFA. Like, so it's, there's a double-edged sword there a little bit. The other thing I wanted to ask you, which I think is super interesting in the point you're making about the commission, like I actually think that I'm not sure that the FTC jurisprudence is going to radically change in the next administration, even if when it's 3-2. Is that your take too?
100%. The big question, of course, is whether somebody will fight them in the way that LabMD fought, in the way that the hotel chain Wyndham fought them.
Yeah.
Up till now, the FTC has survived those challenges. Can you pack cybersecurity into the word unfair? So far, they've been sustained by the courts on that. But obviously, we are post-Loper Bright. We are post-West Virginia versus EPA. We've got a different Supreme Court. We've got a different skepticism. We've got the major question doctrine. We've got the non-delegation doctrine revitalized. So I think, look, at some point, somebody is going to say, no, we're not going to settle. We're not going to go into this negotiation. We're not going to come up with this list. And to me, then the whole house of cards could collapse.
Well, and we'll talk about that in a second when we talk about the SEC. But the only other thing I just wanted to add about the FTC is, so people probably know that in certain instances with health information, with financial information, companies now, in certain contexts, have an obligation to notify the FTC. So if you have a breach, in addition to notifying HHS or notifying the states, you have certain contexts in which you're obligated to notify the FTC. I have learned recently that the FTC is planning to issue quarterly reports that is going to list the name of the company that reported, the number of individuals who were impacted, and the information that was compromised. So that's going to be, people, we all know, like Vermont publishes, California publishes. Very soon, the FTC is going to start publishing. And so that's kind of a new development for 2025 that just people should be on the lookout for, that I think is going to be impactful.
And just to be clear, these are the reports, for example, under Gramm-Leach-Bliley, FTC has regulatory authority over certain, sometimes people call them non-bank banks or non-bank financial institutions, which is a very, very broad list. Mortgage brokers, certain car dealers, certain travel agents, check cashiers. And in November 2023, effective in May 2024, the FTC amended its Gramm-Leach-Bliley rule, saying, don't only notify the affected customer, traditional breach notice, tell us. And what you're saying now is they're looking at that and thinking about, up till now, those reports have been confidential.
Correct.
Right?
Correct. And now they're going to start publishing them. And they're not publishing them in aggregate. That's the part that's like, I think we all thought they would publish but now what we have learned is they're planning on publishing them with attribution, right? It was the ABC company. It's the, XYZ company. So that they may also publish trends and aggregate other insights as well, but they're going to actually name names, which is different.
Yeah, absolutely. One quick other note, of course, on FTC, just very quickly, in April of last year, they adopted an amendment to their health breach notification rule, which is separate from the HIPAA breach notice rule, which applies to hospitals and insurance companies. The FTC, again, has a small piece of this, but they said in this April 2024 rule that it includes fitness apps. And if there is a breach or an unintentional but unauthorized disclosure of fitness app, health app data, then this breach notification rule clicks in, notify the affected individual and notify the commission.
And I think a lot of people forget, because they are, those two buckets are pretty broad, the financial and the health, that people forget that, to add the FTC to the list of regulators that you need to notify.
Exactly.
I think it's a really good point.
Good point. SEC.
So you say that the FTC has been the cyber regulator. Actually, the SEC, the Securities and Exchange Commission, thinks they have been the cybersecurity regulator, and they actually have been. They were very active in 2024. So in October, for example, the SEC settled cases with 4 companies, basically alleging that they had a SolarWinds related cybersecurity event. And as a result, they did not appropriately update their disclosures, or their disclosures were too hypothetical. They also, in one instance, said that the information that they had internal controls problems. But really, the focus on the 4 cases was really on disclosure. Then they find those companies between 990,000 up to 4 million. So actually pretty steep amounts.
And by the way, were those actions brought under this relatively new rule on disclosures of cybersecurity events, or were they brought under the earlier pre-existing?
This had nothing to do with a materiality decision. None of these were alleged to have been material, right? So this wasn't about the 4, the 4 days to file an 8K. This was hypotheticals in your annual disclosure. So so the way historically, and I'm going to go on a little bit on a soapbox, right? Historically, risk disclosures were about like what could happen in the future. There could be a hurricane and we could lose our manufacturing, and that could have a material effect on our company. But what the SEC was saying in these cases is, if you have had a breach, you can't say, I might have a breach in the future. You have to say, I had a breach and I might have a breach in the future. So it's the hypothetical nature. And one of the things that's really interesting is if you look at the dissents by the Republicans in those 4 cases, is they said, this is a Monday morning quarterbacking. And 2, of course, it's like, it's that it doesn't have to be like, full confessional, right? Like that's not the point of a risk disclosure. A risk disclosure is about the risks. So of course they're going to be forward looking. So there was a real tension within the commission, even with these 4 cases when you read the dissent. And then there was another settlement in December for $3.5 million with a bank that was the victim of a ransomware attack. Again, same hypothetical, like, right, it was, we say it, it may interrupt our activity even though it already happened. So that was the same. But what was interesting about the December case is they also said, and this goes to your new rule point, they said that the company's internal policies and procedures did not have enough specificity of the factors to consider when assessing materiality. So this kind of takes the concepts of the new rule. So the new rule says that when you're thinking about materiality, you have to think about both quantitative and qualitative. You have to think about the operational risk, the litigation risk, the reputational risk, the financial risk. You have to take all those things into account when you're thinking about materiality. And what this decision said was that their policies didn't articulate enough what those factors should be, which is really an interesting, an interesting development, because that's the first time that we've seen that. The other thing that's sort of interesting in the SEC world is going back to your point about, is a company willing to sue? So the SEC brought allegations against SolarWinds for their incident several years ago. They went to court. A federal judge threw out like the vast majority of the allegations against SolarWinds. So there were some very, I'll say, creative theories that the SEC had posited using this concept of accounting controls and trying to apply that to the cybersecurity incidents, almost basically saying if you had a cybersecurity incident, by definition, you had an accounting control problem, which really, I think, the court basically said that's just going too far. It's completely changing the statutory language. There's no basis for that.
It takes what is really an accounting rule, which is you've got to have good books. You've got to have good books. The numbers that you state to the investing public, we're talking here about publicly traded companies, the numbers that you give to the public have to be good, and you have to have the controls internally to make sure that your financial statement is accurate.
Right.
The FTC tried to basically turn that into a cybersecurity control.
The
SEC tried to turn that into a cybersecurity control, meaning you had to control all of your assets.
Right. And they got whacked down for that. Yeah. And what was left, which is sort of interesting, what was left in the SolarWinds case is that they had a white paper on their website that talked in quite a bit of specificity about their cyber controls. And that's the part that's, and that was apparently, allegedly divergent to what the internal IT security team was talking about with respect to their security controls. And so the court said that claim can survive, and that case is still going to be tried. But what does that tell you? So that tells you, one, make sure that whatever's on your website, even if it's marketing, right, like it's got to be accurate, because the SEC, that part survived. And the other thing is that there's a huge level of concern in the CISO community, because in the SolarWinds case, it's not just the company, but it's also the CISO who's personally named in that litigation. And so I can't tell you how many CISO organizations or CISOs individually I have talked to in the past year who are saying, well, what do I do to protect myself? So my advice just overall is, your CISOs, talk to your lawyers, right? Like your lawyers are your best friends, right? So, in this context. So, if the lawyers should be able to help looking at that, vetting that stuff that's going out on the internet, on the blogs, and all that stuff. Really, that is just, you really need to have your CISOs and your lawyers like working hand in glove.
And that's critical, even when you come to this question of what is material, what is an event.
100%.
The CISOs and the lawyers need to be talking the same language.
Exactly.
It starts with that communication.
100%.
Let's look for a minute at FCC, Federal Communications Commission. We saw this fall that Chinese government hackers were deep into the networks of major American communication service providers. All the biggies had been compromised in one way or another. The Chinese government acquired a lot of call detail records, millions of them potentially. They may have acquired information about the wiretaps that were being conducted by the FBI. And in some cases, they actually acquired call content information on some selected targets. On January 15th, the commission adopted, January 15th of this year, 2025, the FCC adopted a declaratory ruling finding effective immediately that there was an affirmative obligation on telecommunications carriers to secure their networks from unlawful access or interception. The commission found that authority in Section 105 of the Communications Assistance for Law Enforcement Act, or CALEA. CALEA was intended to protect, in my mind, Section 105 was intended to protect the intercept functionality, which is built into the telecoms switches as a result of this law dating back, I guess, to 1994. CALEA was 1994, required companies to design their switches so they are basically wiretap friendly, so that they can be accessed easily by the government with a court order. It's not clear to me that the Chinese actually exploited the CALEA capacity. In fact, the more we learn, I think they did not exploit the CALEA capacity. They exploited other vulnerabilities in the communications networks.
And can I just add on
yeah.
to that, onto that? So what's
Yeah.
really interesting about this is that many companies now have endpoint detection tools on their servers, on their laptops, and that's kind of becoming like, that's become standard. Like, it's expected that you should be have some kind of endpoint detection tools. But what's fascinating about the phone companies is what the bad guys exploited were devices that are unique to the telecom industry that no endpoint detection tool will work on. And because, some of it is it's unique because of the way their operating systems work. And no software is designed for that. So it was a brilliant operational strategy on behalf of Salt Typhoon, which is the name of the bad guys who did this, to find a way and got into all 9, at least that's public, right? All 9 of the, by using this same unique process. And the concern is they're doing the same thing for power plants,
Exactly.
or bridges,
Exactly.
right? Because there are unique.
This is the whole world of industrial control systems, SCADA systems, other programmable logic controllers. All of these devices that control industrial processes, both physical, opening valves on water systems, et cetera. And this, to me, represents, although Colonial Pipeline was arguably the first, the expansion of cybersecurity from the protection of personal data. That's what we talk about with the FTC. That's what we talk about with the DOJ rule, to also look at the industrial control systems, the Internet of Things, the industrial Internet of Things.
And it's because people think that what the plan is, sorry, maybe you were going to say this, Jen.
Well, yeah, go ahead.
I was going to say is, the thought is that what the Chinese are planning is, okay, that if they decide to invade Taiwan and the US says, hey, cut that out, they'll say, fine, we're going to take down New York City.
Yeah.
Right.
Yeah.
So it's not about stealing data. It's not about
Exactly.
interrupting anything right now. It's future proofing to basically have leverage over the US, which is a brilliant national security strategy.
And the second half of what the FCC adopted on January 15th was a notice of proposed rulemaking to require communication service providers to adopt and submit a certification to the commission that they have cybersecurity and supply chain risk management plans. Then Commissioner Carr, Brendan Carr, who on the 20th of January became FCC chair, Commissioner Carr dissented from the declaratory ruling from both the CALIA half and the NPRM half, and criticized it, said we need to do something, but he didn't say what it was they needed to. Now, meanwhile, and it'll be very interesting to see where that goes, because ironically, up till now, the FCC has not been prescripted. It has not developed regulatory requirements. I believe they do have the authority. It's a little bit of a stretch, but they are, by statute, the Communications Act says the commission shall regulate the nation's telecommunications infrastructure for purposes of national defense.
More than the SEC for sure.
Exactly. It's more, it's stronger. Meanwhile, it's interesting, the FCC has gone a little bit the FTC route and has brought cybersecurity enforcement actions. And last year, they brought and obtained settlements against all three of the big mobile providers, AT&T, T-Mobile, and Verizon through Verizon's subsidiary TracFone. All three of them had been compromised in various ways, and all three of them, the FCC brought enforcement actions citing Section 222 of the Communications Act and Section 201B of the Communications Act. All three companies settled, all three agreed to orders with this long list of security controls and practices. And so in a way, the FCC accomplished, at least with respect to the mobile providers, what they chose not to pursue or chose not to try to do through regulation. Where all this goes under Commissioner Carr, I think, is a question. I think we can be sure the FTC will continue on its path. In my mind, it's sort of open now where the FCC goes.
Yeah.
Any disagreement?
No, I totally agree with you. And I just want to add one other thing, which is sort of an interesting wrinkle. Historically, FBI and DOJ were opposed to end-to-end encryption for communication, right? You know, there was a big fight between Apple and you know, the law enforcement about getting a backdoor into mobile devices. After Salt Typhoon, the FBI is recommending that people use end-to-end encryption. So it's going to be really interesting to see also what the FCC does with that, right? Does their position change? Like, so that, I just think that's going to be a very interesting kind of development.
No, and I think, right, am I right or wrong, though, end-to-end encryption does not protect the metadata.
No, but
and that can be highly revealing.
It can be, but like if you use Signal, or you know, you can have it's very much ethereal messaging. You know, you can have it as soon as the person sees it, it gets deleted, right? So at least that you communicated is going to be there, but the content is gone, right? And so that's what they're recommending for anything sensitive. Use end-to-end encrypted, which is a huge, like a total flip
compared to the so-called crypto wars of the late 90s. Absolutely, complete sea change. I want to mention the HIPAA and the Department of Health and Human Services and its Office of Civil Rights. The Office of Civil Rights at HHS has been very active over the years on enforcement of the HIPAA security rules. So there's HIPAA privacy rule, and there is a HIPAA Health Insurance Portability and Accountability Act security rule. The Office of Civil Rights within the Department of Health and Human Services continued throughout last year and up until even last week to bring cases, including against companies that suffered ransomware attacks. At some level, this almost seems a little unfair. Like, oh, the bad guys came after you. Now we're going to come after you because the bad guys succeeded. The OCR at Health and Human Services has now, I think, brought 10 of these cases in the past 18 months or so against ransomware victims specifically. Companies settled relatively small fines, but again, these corrective action orders that are entered into where the companies agree to take additional measures to improve their security in order to comply with the rule. Because in each one of these cases, the government found in its investigation, HHS found in its investigation what the victim company had done wrong that allowed the bad guys in. I would say I think that is likely to continue. The OCR, the Office of Civil Rights, has this thing called its Risk Analysis Initiative, which it launched last year. This was created to focus investigations on compliance with the provision of the HIPAA security rule that requires a risk analysis. All cybersecurity is risk-based at some level, and it all starts with the risk analysis. And in a number of these cases, the OCR found or alleged that the respondent company, the victim of the ransomware attack, had not conducted an adequate risk analysis, got breached, reported the breach. Many of them, almost all of them, I think, self-reported the breach. That triggers an investigation. One more thing on HHS, massive rewrite of the HIPAA security rule proposed on December 30th. Just before the ball dropped in Times Square, the HHS came out with a major rewrite. The provision of the proposal is open for comment until early March. That time frame may in fact be extended. Certainly the rule will not be quickly finalized. A lot turns on whether there's significant industry pushback. I'll just say the current rule is completely outdated. And I cannot believe that there is a single covered entity that does only what is required in the rule as written. The rule doesn't even require, as I read it, the HHS disputes this a little bit, it doesn't even specifically require encryption of data at rest or in motion. It doesn't even mention multi-factor authentication. It doesn't even mention patch management, network segmentation, disabling network ports, pen testing. Fundamental elements of the modern concept of cybersecurity aren't even mentioned in this rule, which dates back to 2003. So it is seriously in need of update. Again, it's a little bit like what you were saying with the contrast between the FTC and European enforcement. At some level, I think industry would welcome, tell us what to do. Right now, all these things are addressable. Basic things aren't even mentioned. Nobody knows how good is good enough.
No, you know what a great analogy to this is the New York Department of Financial Services. Everybody complained when their new rule came out because it was prescriptive. It's right. You know, you have to have these things, but every financial institution was already doing it. And so it actually gave, I shouldn't say every, you know, every reasonably responsible financial institution was already doing it. So it's giving people actually confidence and assurance that they are meeting the industry standard. So I don't know that there's going to be that much pushback for HHS because yes, first people would be like, oh my God, it's so prescriptive. But then I think there is some comfort if HHS is saying this is our expectation.
Yep. And again, that conversation between the general counsels or the outside counsel and the CISOs may say, oh, of course I'm already doing this. I don't care whether it's required or not. I'm already doing it.
Right.
Well, you mentioned New York State, and a lot has been happening at the state level. Give us a sense of what we're seeing at the state level.
Sure. So, you know, we've been seeing this trend for a long time at the states, you know, with varying kinds of rules like, oh, you know, this is what you have to do to have secure disposal, or that's what you have to do in order to limit somebody's time to give their password to get access to a website. Obviously, all the breach notification, we don't have a federal breach notification rule, but you know, we've been seeing this trend, and including, you know, the need to supervise service providers. So we saw 6 laws adopted last year that included specific data security provisions: Kentucky, Maryland, Minnesota, Nebraska, New Hampshire, and Rhode Island. 5 of those, it just is the same boilerplate. You need reasonable administrative, technical, and physical data security practices, but absolutely no detail.
Just to be clear, the laws you were referring to are these comprehensive
Correct.
privacy laws
And have a data security section. 100%. Correct. So like, you're right. I should be more precise. We've seen these kind of very specific ones. And now as everybody is adopting all these, you know, comprehensive ones, there's a little tiny bucket about data security, but it doesn't say anything. Except Minnesota is the one that actually has some more detail to it. It requires an inventory of the data that you're responsible for and a description of the policies and procedures that you have in place. So, you know, again, we're going to start to see that kind of differentiation between the states. Nothing is super surprising if you have a global program. You know, if you're, it's again, just it's going to be a little bit of a Christmas tree approach, I would say. You know, different states are going to focus on the things that they're the most interested in.
Right.
And then I'll just say one thing about enforcement, and then I'd really like to hear your view on enforcement, Jim, which is, you know, a lot of people think, oh, it's just the blue states that are interested in enforcement on consumer protection, and it's just not true, right?
Texas, man.
Florida, Indiana, they are the 3 of the most active enforcement, you know, in terms of data security, right? Is that your?
Oh yeah, 100%, 100%. You know, by my count, we now have 19 states with these comprehensive data privacy laws: opt-out, notice, access, correction, etc. Every one of the 19 have this also: protect data with reasonable security measures provision. And then a number of states have these freestanding data security provisions that say anybody who collects personal data, check the definition of how personal information is defined. It varies among these laws. And when you put it all together, some states have both, actually. Some states have a freestanding data security provision and a provision in their comprehensive privacy law. I now count 31 states that have a requirement that an entity collecting, or to use the European term, processing personal information must protect that information with reasonable security measures. But on top of that, all 50 states have some form of a consumer protection law, sometimes called mini FTC acts, or sometimes called UDAP laws, unfair and deceptive acts or practices. A few of the state laws only cover unfairness, a few only cover deception. Most of them cover both, as well as some other terms. New Jersey state law makes it illegal to engage in unconscionable trade practices, etc. And pretty much every state has taken the position, if they have an unfairness law, they've taken the position, just as the FTC did, that it is an unfair practice to collect consumers' data and then fail to protect it. So the states have this variety of tools, and as you say, not only the blue states like California, New York, but some very conservative states. These states now have dedicated privacy and data protection or cybersecurity units or individuals tasked with this, sometimes in a Bureau of Consumer Protection, sometimes in a Bureau of Internet and Technology, within the State Attorney General's office. New York has been particularly aggressive. Attorney General James has been getting settlements at about the rate of one every other month. I don't know, she had 6 or 7 in 2024, got $500,000. And by the way, she enforces against insurance companies, which are also separately regulated by the New York State Department of Financial Services. So you've got 2 regulators in New York, the DFS, Department of Financial Services, which covers banks and insurance companies, and again, a very broad definition of financial institution. The DFS went after, not last year, but a couple of years ago, Carnival Cruise Lines. Carnival Cruise Lines was investigated, and an action was brought against them because I think you can buy your cruise on credit, or, you know, on some payment plan. That made Carnival Cruise Line a financial institution subject to the New York State Department of Financial Services regulation. So certainly looking ahead, absolutely, we can expect states to continue to be active, both on these, I would say, relatively small cases, you know, $500,000 settlement Letitia James got against an auto insurance company, Nobler. She got 4.5 million against a biotech company, 11 million against Geico and Travelers for poor data security. But then also these sort of blockbuster cases. So we saw late last year, the states, 47 of them, I think, settle against Marriott. Marriott had suffered a series of breaches stretching back over a number of years, I think 2014 to 2020, resulted in a class action, resulted in an FTC investigation and enforcement action. And the states join together, they collaborate, one state takes the lead, and then all of the individual states file complaints under their own state laws, and then there's a single comprehensive settlement with the states with a dollar figure that gets divvied up among the states. And again, this long list of security requirements. Actually, Marriott was 49 states plus the District of Columbia. I think we're likely to continue to see that.
I do too. I think that the multi-state AG action, that goes all the way back to the Target, right? Like
Yes.
that is not a new thing.
Correct.
And it's red and blue states, and I see no reason to think that that's going to go away. Like the states are going to continue to join forces and, you know, get a piece of the settlement when they can. 50
state breach notice laws. So if there's any delay or failure in the breach notice, all states have that weapon enforced by the Attorney General. Now 31 states with reasonable security measures, pretty much every state with some form of a UDAP or consumer protection law, and then these more specific laws like the New York Shield Act,
right.
Or sector-specific regulations. I think now, at least a dozen, maybe just shy of 20 states have adopted the uniform law on insurance data, regulating the insurance, cybersecurity of the insurance.
Well, and can I just say one last thing about the multi-jurisdictional aspect of this? One of the most important things to do is to make sure that what you say to one regulator, you say to another regulator.
Oh,
so if you have a breach that affects the people in 30 states, the information you give has to be the same because the regulators all talk to each other. It's actually true globally, right? The regulators around the world talk to each other. And one of the biggest mistakes that organizations make is they, not intending to lie, but they have to like, oh, you go notify in Japan and I'm going to notify in Kansas, but they talk to each other and then somebody thinks you're lying. So it's incredibly important that when you have a multi-jurisdictional issue from a breach perspective, that everyone is singing from the same page.
Miriam, very quickly, what's happening on the private class actions?
So I'll do this super fast. What's happening on private class actions is that basically old concepts like wiretapping are being reused with new, you know, where you're seeing new technology. So the plaintiff lawyers are bringing cases, for example, against organizations that have a chatbot on their website saying, hey, I I, the consumer, I thought I was actually communicating with my airline. And I was using that chat bot that's being provided by a third-party service provider. So that's a wiretapping interception. And so the wiretapping laws are about two parties talking and a third person coming in.
Yep.
So they're taking that concept of the
Interesting.
wiretapping laws and applying it to chatbot and to pixel tags and to, all different other kinds of like pen registers and trap and trace. So it's actually fascinating to see how these laws, which were written that have nothing to do with the technology to which they're being provided, is now, I'm sorry, which is being applied, are now being used. Some of those are more successful, some of those are not, but we are definitely seeing incredibly active, a ton of activity in the plaintiff's bar using those theories with new technology.
And meanwhile, you still have the steady drumbeat of negligence-based claims in cybersecurity cases. And
Sure.
I mean, my sense is the courts, federal courts, where a lot of these cases end up one way or the other, the federal courts in many cases are continuing to find standing and continuing to let those cases go forward. Do you see any trend there? I mean, on standing?
No, not really. I mean, nothing. I mean, I think I agree with you. I think the courts are kind of all over the place, right? Some are finding standing, some are not. Most of these, like the vast majority of these cases settle out. And so, there's a lot of effort by companies to just not be a good target, of these kinds of cases. But yeah, I don't see a trend like that, like one way or the other in terms of how the courts are looking at these.
Let me do a couple quick hits, and then I want to close with Cercia, because I think Cercia is going to happen probably, but I'll let you handle that. Couple things to look for in the coming year. As I said, the HIPAA safeguards rule now falls to the new administration to take across the finish line. Meanwhile, the Commerce Department issued late in the year an advance notice of proposed rulemaking on drones. Actually, President Trump in his first term tried to regulate foreign-made drones being purchased and used in the United States. The Commerce Department now, late in the Biden administration, picked that up, but left it to the new administration. And the Commerce Department, again, at the end of the year, again, picking up on a theme that in a way began under Trump and the Trump Executive Order 13873, the Commerce Department adopted a rule limiting the import of connected vehicles and components for connected vehicles from China or Russia. That was a final rule. How hard it will be enforced, it falls to the Commerce Department's Bureau of Security, BIS. Hard to know. One note, President Biden issued 2 executive orders on cybersecurity, one relatively early in his administration, one late. Neither of those have been repealed. Again, the Trump administration might choose to ignore some of what was in the most recent order, but so far, nothing repealed there. The AI order, of course, was repealed, but that didn't, strictly speaking, speak to cybersecurity issues. So let's close out on Cercia.
Yeah.
Will we see, tell people what Cercia, remind people what Cercia is, and will we see a final rule?
So Cercia is actually based on legislation, so it can't be repealed by an executive order. And essentially what it says is that critical infrastructure organizations are going to have certain obligations, including reporting within 72 hours if there's a breach, reporting within 24 hours if they pay a ransom. But the thing that's interesting about Cercia is who is in scope. Basically, everybody other than a law firm is considered critical infrastructure. Like, the supermarket,
Exactly.
the casinos, like as well as, of course, the banks and the utilities and all the things that you would expect. So it's much, much broader. Lots and lots of organizations are like, I'm not critical infrastructure. I have nothing to do with this. Totally not true, right? Like mom and pop grocery stores and law firms. I swear to God, like those are the two exceptions. So it's definitely, the rules are supposed to be finalized by the end of 2025, with this coming into effect in 2026. It's possible, and I would think rational, that the scope is narrowed, because there really is a big disconnect between the language of the statute and what the proposed rules have, and particularly post Chevron. Like, I think I could definitely see a court saying, come on, like, right, like, like every supermarket is not critical infrastructure. So, but I definitely think, we are going to see those rules. Everybody, like 72 hours for notice is becoming the standard globally. Like that's just
really interesting.
So that, like, just if you look ex-US, it's 72 hours is everywhere.
Wow.
Unless it's shorter. Right?
And again, this is not public reporting. This is reporting to the regulator.
To the regulator, exactly. You have to
case,
tell your regulator in whatever jurisdiction, whether it's a data protection authority or it's your, the IT regulator. It depends. Different jurisdictions, it's different. But it's 72 hours is becoming the norm. Yeah.
And just
that's
to be
what we're going to see. And I don't think that's going to change. I think the 72 hours and the 24 hours for ransom, same. I don't think that's going to.
And just to be clear, these reports by statute must be kept confidential by the government and cannot be used for regulatory purposes.
Well, in theory, in theory for enforcement, but I'll believe that when I see it.
Yeah. Well, Miriam, you and I could go all day, but I think we've imposed upon people's patience enough for this particular session. It's a real thrill to have done this with you. Wayne, back to you for any closing remarks.
So I'm going to leave the listeners with a quiz. You mentioned 49 states signed on to a suit. The question is, who was the 50th and why? So
you will be surprised.
Yes. Well, don't tell people.
No.
That'll be the next time. We'll stop the recording and you
credit.
can tell me. Yeah,
okay.
It proves I was listening. So this is for a patent lawyer. It's tough to listen to cybersecurity and privacy sessions. This one was fantastic. So if you can entertain an old patent litigator, everybody else is going to be in great shape.
Thanks, Wayne.
Great.
Thank you so much.
All right. Take care.